What does a recent legal case mean for digital assets? Hello, I'm Dominic Walker. Welcome to JMW's Inside Man YouTube channel. Please subscribe to the channel, like this video, and keep the conversation going in the comments section as well. So there's been a recent legal case which is all about arbitration clauses. It's been against Nifty Gateway. Georgie Clayton is a trainee solicitor within JMW's commercial litigation department, and amongst other things, Georgie specialises in digital assets. So many people may think they know what an arbitration clause is. What is one, Georgie?
So an arbitration clause is ultimately a clause in a contract in which parties agree that they will settle and they will resolve any disputes that arise out of it out of court, and they will do so in arbitration. So ultimately, they are forfeiting their right to issue court proceedings, and they are quite common in commercial agreements. And, businesses generally don't want to open themselves up to, time-consuming, drawn-out litigation in the event that there is a dispute with a consumer or a customer. And I think that's something that consumers don't realise.
And so what's happened in this case, Georgie?
Yeah, so ultimately, a consumer has placed a bid in a ranked online auction for an NFT. And as a result of that bid, a dispute has arisen out of the auction, and the platform on which the auction took place decided to issue arbitral proceedings. And it did so based on a disputes clause that it had in its terms and conditions. And ultimately, that clause provided for binding arbitration in New York. And the consumer decided that he was going to issue his own proceedings here in the UK because he ultimately wanted to protect his rights as a consumer. So there were, a number of legal issues in play here, but for our purposes, his claim was premised on the idea that the disputes clause was unfair, and so it couldn't bind him because it was actually contrary to English consumer law, so the Consumer Rights Act 2015. And so the platform decided to seek a stay of these English court proceedings. The High Court decided to initially grant the stay, and they believe that this arbitration clause should be looked at by the arbitral tribunal in New York. So the consumer, of course, wasn't happy with that and decided, I want to appeal this. So he went to the Court of Appeal. And the Court of Appeal actually decided to lift the stay, and they said that they should be able, so the English court should actually be able to look at this arbitration clause and say whether or not it is valid. And I think they did it for two main reasons, and I think this is really where the judgment takes its play, really. So they said it's a ruling that will affect consumers and consumer rights, and as such, it will have implications for consumers in general. And so it should be ruled upon in a public court. It shouldn't be ruled upon in private at an arbitral tribunal. And they said also that consumer law and consumer protection rights under English law do actually involve domestic concepts. And, they should be placed upon and ruled upon in an English court, and an English court will be far better to do so. So we all almost see in this judgment kind of a primacy of consumer rights protection over an arbitration clause, which is where it is quite unique, really.
And how can you and the team here at JMW Solicitors help anyone in a similar situation?
No, so cryptocurrency exchanges, will continue to include these clauses, these arbitration clauses in their standard terms and conditions. And unfortunately, as we know, they are big, they have better standing. And so, this isn't going to change. We aren't going to see these clauses automatically disappear from them. But, the case did leave some open questions. And one of those is, how readily will the English courts actually be to invalidate arbitration clauses in the name of consumer rights? And, there is the English High Court trial on this point soon. So we will hopefully have an answer or more of an idea of how readily they will be to invalidate them. And so, the water still does, I would say, remain quite uncertain. But, here at JMW, we have a great team of commercial litigation solicitors who do have expertise and experience, shall we say, on these disputes. So, they have experience in challenging arbitration clauses, unfair contractual terms. I mean, it's something we regularly advise on. So that's how we can kind of assist on that point.
Georgie, thank you very much for your insight. And if you'd like to contact Georgie and the digital assets team here at JMW Solicitors, you can email insideman@jmw.co.uk or call 0161 82 81 999. Please also subscribe to the JMW Inside Man YouTube channel. I'm Dominic Walker, JMW's Inside Man.